be on this great campus and be able to partner with the SMU community and its world-class faculty, and we've always enjoyed sharing our programs with SMU students and the broader community.
In addition, principled leadership never goes out of style. President and Mrs. Bush have set the example, and we want to follow it.
My hope is that the Bush Center will always serve as a place where timeless principles are celebrated, protected, and promoted. We've had a great start. Now we must make sure our mission endures for generations to come.
Ladies and gentlemen, please welcome the Executive Director of the George W. Bush Institute and Vice President of the George W. Bush Presidential Center, David Kramer.
Good evening and welcome, and thanks to all of you for being here for a special Saturday night Engage event at the Bush Center presented by NexPoint. We're very grateful to NexPoint for its support for this year's programming and for endowing our Engage series. We're also grateful to see a number of board members here and members of our Executive Advisory Council, and thanks for being with us here tonight. One of the strengths that we have at the Bush Center is that we're on the campus of SMU. And joining us here this evening, we have the pleasure of welcoming the Dean of the SMU Dedman School of Law, Jason Nance. Jason, it's great to have you with us here this evening, along with a number of your students, I believe, too. We are honored tonight to welcome back to this Engage series Supreme Court Justice Neil Gorsuch. Justice Gorsuch is a native of Denver, Colorado, and he earned his undergraduate degree at Columbia University, his law degree from Harvard Law School, and PhD from Oxford University. His career in the law includes clerking for Supreme Court Justices Byron White and Anthony Kennedy. He then spent 11 years in private practice before serving as Principal Deputy Associate Attorney General at the U.S. Department of Justice. President Bush appointed Justice Gorsuch to the United States Court of Appeals for the 10th Circuit in 2006, and he then joined the Supreme Court in April of 2017. Justice Gorsuch is here tonight to discuss his new book, Overruled: The Human Toll of Too Much Law. And President of the Bush Center, Ken Hersh, will be moderating tonight's conversation, which I know will be a fascinating one for all of us. After the conversation that Ken and Justice Gorsuch will have, you'll have the opportunity to get a copy, a signed copy of his book, which will be in Hall of State just outside here. And if you didn't get a chance to purchase a copy of the book, you can also take care of that in Hall of State as well. I hope you understand that he won't be able to personalize any copies of the book, but looks forward to signing copies for you. So with that, thank you again, all of you, for being here. Please help me in welcoming Supreme Court Justice Neil Gorsuch and Ken Hersh.
Thank you for being here on a Saturday night. I know you had the top of your weekend plan was to be here in Dallas with us, and thank you for all you visitors tonight with us on a special event, because we don't usually do things on Saturday night, but it's really a treat to have you join us.
Well, we got a little one here too. Well, thank you for being here, the next generation. Saturday night in Dallas, you have better things to do, so I really appreciate you coming out. Thank you.
Well, so because we all like talking about this on a Saturday night, we're going to talk about the state of I'll call it the rulemaking maze that you describe in your book. And it's a powerful book and a powerful message where you make the point that the explosion of laws and regulations hurts a number of things that we value in this country. The rule of law, aspirations of self-government, the Constitution's separation of powers, individual liberty, respect for trust in law and the justice system, and equality. Those are all big, bold statements. I want to have you start with some context. Your first book was called A Republic If You Can Keep It. Why don't you bridge us from the message of that book to the more granular message of this one?
So this is more granular, Ken, you're absolutely right. And I think what inspired me to write this book was, I've been a judge now for about 18 years, and I have just seen so many cases in which ordinary Americans, simply trying to do good things and live their lives and go about their business, suddenly getting thwacked, and there's no other way to put it, by a law that they didn't see, couldn't have reasonably anticipated, and facing a loss to their life, their liberty, their property. And I'll just give you a couple of examples of things that started niggling at me. You know, the veteran who does everything right and ticks all the boxes, but the agency still denies him disability benefits because they had a rule that they now admit is unlawful, but they followed it perfectly. The immigrant to the country who follows all the rules, ticks all the boxes, and those are lots. I remember I couldn't fill out my wife's forms when she immigrated to this country very well, who relies on judicial precedent and is told after many years he has to start over again because the agency disagrees with the judicial precedent on which he relies. A small healthcare company in Kansas who provides home health care services accused of fraud and defrauding the federal government, complete risk to their business. And it turns out after 6 or so years of litigation, all the way through administrative agencies into our court, on the Court of Appeals, that they had followed all the rules in place at the time, and the government had gotten confused and was accusing them of violating rules that it promulgated after the conduct in question. Or a simple case, young man in New Mexico, middle schooler, I think, burping in class. Some of us might have done that. Instead of taking to the principal's office, having his mom called, he's handcuffed and arrested. And I've just seen so many of these cases, Ken, that I just wanted to explore more deeply. I felt like something's going on in our law. Something's changed about our law, and so I wanted to explore that. And that's what led to the book.
Okay, so by way of background, so you make the point that the law in this country is king, and one of the points that you make is perhaps that because we don't have a common heritage as Americans, that we really are a melting pot of diversity, that we need the law to kind of manage us. And so we're more accepting of the growth in this massive administrative state. You talk about the Federal Register adding something like 70,000 pages annually. And is it true that you could be found criminally liable for violating a law that was not even published?
Well, let me start with the premise.
Yes.
We are definitely, and I'm profoundly a believer in rule by law and written law. I mean, it'd be kind of crazy to do the job I do if I didn't believe that. And, you know, our founders, we started with a written constitution, and that was a novelty. That itself was a revolution, that our foundational document would be a statute, a super statute, and that you could rely on those written words. So don't count me as an anarchist here, but far from it. But something's happened in our lifetimes, maybe not that young person's lifetime over there. And just to give you a sense of it, 100 years ago, all federal law passed by Congress could fit in one volume. Today, it occupies a massive wall in my office. You don't think Congress does much these days, right? They pass 2 to 3 million words of new law every year. And that's the tip of the iceberg. They now delegate a lot of lawmaking authority effectively to regulatory agencies. 100 years ago, Justice Brandeis fought to have those agencies write them down and publish them in what became the Federal Register. The government fought that at first. Said, we're not in the newspaper business. So you couldn't find, there was a case, and I talk about it, it came before the court. Nobody could find the regulation. They literally couldn't find the regulation. The only copy anybody had seen of it was in the hip pocket of an agent who would come down here to East Texas in the oil fields where the case was involved. Anyway, it was crazy. First edition, 16 pages. Today, the Federal Register, 60 to 70,000 pages every single year. Now that's, again, even that's the tip of the iceberg, because agencies now often don't just promulgate their rules, they issue what they call guidance documents. They do that so they can avoid the Administrative Procedures Act, which requires them to publish them. So they don't have the force of law, but everybody's terrified of them, understandably, because if that's what the agency's guidance document says, you better follow it, right? You're taking a big risk if you don't. How many guidance documents are there? The honest answer is nobody knows, because they don't publish those. They're not all on the internet. Some of them are still, like the hip pocket incident I talk about in the book, to be found in desk drawers of agency officials. So the scope of our law has exploded. And this isn't a New Deal thing. This isn't a 1930s thing. This is a 1970s onward thing. This is something that's happened in our lifetime. And that's when I was getting deeper into the book, what I was.
So it's not just the volume, it's the common sense. You mention in the book that if I were to call the IRS and ask them for guidance, because I may not know the rule and I call them, if I get in touch with them, if they answer my call, or if they pick up the phone. But if I follow their guidance, I can still be criminally liable for following, and I followed their guidance. They don't even have to be
Correct.
They don't have to be correct in their own guidance.
Yeah, and I've forgotten the figure, it's in the book, but during a period of time, the IRS found that it was providing inaccurate guidance a very large percentage of the time. And Congress asked, well, why is that? And the IRS's explanation was, it's gotten really complicated. I can't remember whether it was Will Rogers or somebody who said that, when you're filling out your taxes, you either think you're a dupe or a felon, and you're never sure which.
Right. So with 430 some odd federal agencies, how did it get to the point where they could be, they have enforcement powers, they can arrest you, they have their own courts, and you could be a criminal felon without ever going through the judicial system as we know it?
Well, Ken, I'm afraid I have to correct you on your premise. I wanted to find out how many federal agencies there are, and I sent my researchers out, and they came back with different numbers from different agencies. So the federal government itself cannot agree on how many agencies it has today. All right, now your number might be one of them, and that's a good one.
I got it out of your book.
All three of them are in the book. So yes, we do have a system now where you are 10 times more likely to be tried by an administrative law judge than you are by a judge, if I can call it that. What's an administrative law judge? How does it work? Let's take an agency. You could take the SEC, you could take the FTC, any of the alphabet soup you choose. If you do something that they think is a violation of the law, they are the prosecutor. They bring the charges. They vote to bring the charges. And then they take you before this administrative law judge. We used to call them hearing officers, but they really like being called judge, so now they call themselves judges, and some of them now even wear robes. Turns out they're just employees of the federal executive branch. Some of them have more protections for their decisions than others, but some can be fired and reassigned if the boss doesn't like the decision. The boss can sometimes say, I just disagree and I'm going to assign it to somebody else. Very few protections compared to an independent judge, right? Why do we have life tenure judges? So I don't care. I can rule for you if you're unpopular. I have that protection. That fellow, that hearing officer, doesn't have that protection, all right? He reports to the same people who brought the charges, often the same people who brought the charges against you. And the procedures are very different that you're going to get in those kinds of cases. You're not going to have the rules of evidence, protections against hearsay. You don't always have the right to cross-examine your accuser, and you most certainly won't have a jury. Well, what kind of review can you get from that? Guess where you appeal to first? The commission that authorized the charges against you. How does that work out? Well, I think the figures from the SEC are they win 90% of their cases in-house. I think the FTC, some commissioner said he wasn't aware of any case in which they had lost before themselves. Now, if you have enough money and you are patient enough, about a decade perhaps, you can then maybe appeal the commission's decision to a real court. But the real court, under contemporary law, until a minute ago, would defer to the agency's interpretation of the law if the law was ambiguous. So you couldn't argue your interpretation of the law fair and square. The scales of justice were tilted against you. And when it comes to the facts, if there is more than a scintilla of evidence, I'm sorry to use that phrase, but that's the phrase. If there's more than a scintilla of evidence against you, you lose. That's the standard of review in the real court system. And you're, again, 10 times more likely to face that adjudicative process than the ones that I think the framers promised us when life, liberty, or property is at stake.
And let's talk about the framers, because the system was designed to make it hard for government to be on our backs. Separation of powers, checks and balances, the tension between federal and state. Madison, in the Federalist Papers, warned that in governments where lawmaking is easy, laws quickly become so voluminous that they cannot be read or so incoherent that they cannot be understood. And they may undergo such incessant changes that no man who knows what the law is today can guess what it will be tomorrow. And you make the point that law is supposed to protect our liberty, and here it is crushing it. The human toll on this is really quite stunning. You talk a story about a fisherman who got in trouble under the Sarbanes-Oxley rules, which was designed after the Enron fiasco to ensure better accounting and responsibility from audit committees for public boards. How'd that happen?
So the book, as Ken alludes to, is a book of stories mostly. I sprinkle in some philosophy and statistics along the way, but it's really about the people and cases I've seen or colleagues have seen. John and Sandra Yates, who you're speaking of, grew up around the Great Lakes. John loved to fish. They're high school sweethearts. They moved down to Florida so he can pursue his life's dream of becoming a commercial fisherman. He works his way up from deckhand to own his own boat, 2 or 3 men on board. And he's out for red grouper. They've been out for a while. And the young man comes up. He's state official, cross-deputized with the federal government. NOAA is the agency, more alphabets for you. And he says, I want to take a look at your red grouper. And John says, well, I got thousands of pounds of red grouper. He says, I want to measure them, and I've got all day. So he takes his stick, and he measures the red grouper. And now John thinks this young man's not very good at measuring red grouper. This is important because they have a lower jaw that sticks out. And the young man's measuring them nose to tail, not to the end of the jaw. At any rate, on that basis, he finds 72 grouper that are under 20 inches. 20 inches being the then regulatory rule, okay? And so John says, well, we can argue about it, but I know I'm going to get a citation. That's life. Guy says, put them in a box. I'll deal with you when you get back to dock. A couple days later, he gets back to dock. Guy measures them again. This time, there are only 69 undersized red grouper. And this guy's very suspicious. John tries to explain that, well, you take them out of cold holds and you stick them on hot docks, and you're not very good at measuring them anyway. What do you expect? Anyway, he doesn't hear anything for 3 years, guys, 3 years, when agents, federal, state agents, body armor, the whole thing, surround his house, come looking for him. Has no idea what this is about, no idea. Gets taken away 2 hours to Fort Myers, where he's charged with a federal felony, among several. One of them is under the Sarbanes-Oxley Act. Now, Sarbanes-Oxley was developed after the Enron scandal, and you might say, what on earth does this accounting statute have to do with red grouper? And the answer of the government's theory is as follows: that the law says something like, and I'm paraphrasing, thou shalt not intentionally destroy accounting records, spreadsheets, and other tangible objects when you know there's a federal investigation afoot. And the theory is, one of the government's theories, apparently, is that John threw overboard 72, threw overboard 72 tangible objects and replaced them with 69 still undersized tangible objects. Now, John says if he'd wanted to throw overboard the undersized, he wouldn't have replaced them. Well, anyway, you get the idea. They offer him a plea deal. He refuses because he thinks he's innocent. Goes to trial, very rare these days. 97% of criminal matters result in plea deals. So John's a brave guy for going to trial. He's facing 20 years for this under Sarbanes-Oxley. By the time he gets to trial, guess what the size limit, regulatory size limit for red grouper is? It's 18 inches. Every fish he had was over 18 inches, over 18 3/4 inches, but yet the government pursues him anyway. He's found guilty. So the judge sentences him only to a month in jail, which is a blessing, he thinks. But it's also at Christmas time, and he's got 2 young grandchildren that he's raising. And he and Sandra ask if they could delay his prison term to after. Nope. So he's in jail. DNA, ankle bracelet, all that stuff later. At that point, he's willing to give up. He's lost his job. They wound up losing their home, moving to a triple-wide trailer. And he's ready to just move on with his life. But Sandra won't give up. And if there's a heroine in my book, it's Sandra Yates. And she insists on taking that case on appeal, and they lose again. And then she insists to at least file a petition to the Supreme Court of the United States. We get thousands of them. We take only a handful. Court grants the cert petition. She wins 5-4. Sarbanes-Oxley Act covers many things, many kinds of tangible objects, but it's got to be like something like the things that are listed, like spreadsheets, like accounting records, not red grouper. They won all the vindication our legal system can afford from the highest court in the land. And yet, what did they win? He had already served his time. He had lost his business. And he was living in a trailer. And he and Sandra were still trying to raise their grandchildren. And Sandra, to this day, says, I did it because I don't want to have it happen to my husband, happen to others. And she's still a little upset she didn't win by more votes.
So on a personal basis, you're sitting on the bench and you hear these cases. You mentioned the one earlier about the VA where the man gets denied benefits that the statute says the VA has to give him. He applies for it, doesn't get them, and he sues, but it was properly applied. When you look at these cases, do you sit there and does your just jaw hit the table and say, I can't believe what I'm listening to?
Sometimes. These kinds of cases stick with you. And that's why I wrote the book, because at the end of the day, I have to apply the laws you give me. And we all do, and we have to do that faithfully. I can only play my role in the system. But at the end of the day, it's a democracy, and it's we the people. And you're going to get the laws, it's supply and demand. And you're going to get the laws you demand, right? And so it's really at the end of the day, and maybe we'll talk more about this later, Ken, but at the end of the day, I'm writing this book for you because if there's a solution, it's going to come from people like you. Supply will always meet demand. And if the question is always, should there be a law against it, there will be.
So let's go back to a case in 1984 that was really important that has been referred to as the Chevron case. And then this court, your court, has actually chipped away at it, reversed it recently. Talk about how important that was to help cause the problems that you talk about in your book, and then maybe this ruling recently is a way for the pendulum to turn a little bit against that wave.
It's a very small thing in the overall scheme of things, I think, Ken, but it affects that immigrant I talked about earlier who had followed judicial precedent in applying to this country, done it exactly right, and then the agency comes in and says, we interpret the law differently, and he did it wrong, and he has to start all over again. And by the way, leave the country for 10 years. He's married to an American, he's got 4 children here, and he followed all the rules. Tough luck. Go out of the country and start over. It's a 10-year waiting process. Or the veteran you're talking about, who follows the rules to a T. The law, that is, the statutory law, to a T, he thinks. But the agency has a rule that's kind of self-serving that says something different than the law.
Right.
And judges will defer to that. And all we did in the Chevron decision is say everybody comes to court on an equal footing, right? Lady Justice, you all see her holding the scales of justice, and they're supposed to be balanced, and she's supposed to be blindfolded, right? Well, Chevron allows you to peek, and it tilts the scales. And it says if there's any ambiguity in the law, the government wins. It's a remarkably efficient rule, right? I mean, the king always wins is a very easy rule for judges to administer, and you might see why it became popular for a period. But it is inconsistent with Marbury versus Madison and our very foundational decisions from the beginning of this republic, and the idea that no man is a judge of his own case, right? We're all equal before the eyes of the law, and it is emphatically the province of the judiciary, as John Marshall said, to say what the law is, not leave it to elected branches to say what the law is. And so that's my view, and it has been my view for a long time about Chevron. And I didn't have any preconceptions about Chevron, frankly, before I became a judge. In private practice, it wasn't something I encountered very much. But as a judge, I started seeing, and who does it hurt? Who does it hurt, Ken? I'm sorry, you got me on a soapbox here.
It's your soapbox.
Yeah, I guess. It hurts people unequally. Who can manage a world in which the law can change from administration to administration? Because they can change their interpretations of the law, their regulatory interpretations of the law, when it's ambiguous. And they do. It flip-flops every 4 or 8 years in a lot of areas. Who can manage that change? The wealthy, who can afford sophisticated lawyers? The clever, who can hire lobbyists? Who can't? It's going to be the people like the immigrant to this country who's trying to follow the rules. It's going to be Thomas Buffington, the disabled veteran. It's going to be people like them who are not going to be able to keep track of the bouncing ball. So it has an equality impact.
Huge. Okay, so one of the protections that's built into the system is the restraint at the federal level and empowering the states and the local levels to do things. To kind of, that federalist system allows us, at least in theory, to protect our liberties from a really aggressive federal branch. You mentioned in your book today that in addition to the 3 million civil servants and 3 million contractors, at the federal level, we have block grants that go from the federal government to the states with all sorts of strings attached, which then has the same effect of pushing down this heavy weight and heavy burden onto the states, which was supposed to be kind of the check against the system. How do we get out of this cycle?
Well, we'll come to solutions in a minute, but let's explore the issue that, at least as I see it. So I think we've been talking a fair amount about how Congress has moved a lot of authority from the legislative branch over to these agencies, right? And lawmaking's moved sideways into the executive branch. It's also moved vertically from the states upward to the federal government. It's up and over as I visualize it. Just to give you a few statistics that kind of drive this home for me. Federal government in 1969 or thereabouts, lobbying, annual expenditures for lobbying the federal government is about $40 million in today's dollars. It's about $4 billion annually now. Back then, maybe 5 of the 25 richest counties were around Washington, D.C. Now it's 10. 1979, the Department of Education, just to take one, didn't exist. Today, it has about 4,000 employees and issues about $70 billion worth of grants every year with strings attached. And those strings attached dollars that come from the federal government have gone from something like $70 billion back then to something like $1 trillion today. So that's what's changed, again, just since maybe 1970, to give you a sense. Governor Ben Nelson of Nebraska famously quipped, he wasn't sure whether he was governor of a sovereign state or merely the branch manager for the federal government in Nebraska. About a third or so of the dollars that states spend today come from Washington with mandates associated with them. And that has profound impacts on our ability to govern ourselves in a federal system where we can live differently in different communities and have different values and different approaches. Louis Brandeis called our federal system, the laboratories of democracy. And for that to work, it can't be all top down. And I do worry we're losing some of that. Now, like any good thing, federalism can be abused and has been abused in the past. And like everything else, we're looking for a golden mean here, I think. And I'm not being critical of the federal government, it does many good things. But I do think everything in life is a balance, and we've gone from one extreme to another very, very rapidly.
Okay, now I want to build on that, because one of the points that you make isn't just about sort of the federal government run amok. Private industry has a role to play also, because private industries and industry associations get asked a lot to help out. And to help, obviously they're lobbying, but then they're asked to help with them, because they're more sophisticated with the rules, the rule making, and then sometimes the rule enforcement. And then you end up with this regulatory cycle where the industry itself is kind of protecting their own, and it produces almost the same effect as some of these crazy administrative laws.
I think what you're talking about is regulatory capture.
Regulatory capture. I was teeing you up for that question.
Okay. Got it. And that is, you've all probably heard of the phenomenon, but it gets back to the idea of, okay, if everything's going to be done not in the legislative process where your elected representatives are speaking for you, but in this other process with unelected people in agencies, most of whom you've never heard of, who's going to be most effective in that arena? And who's going to spend the time and the effort to read the Federal Register? I mean, is that something you crack open with a glass of Chianti next to the fire? Who's going to comment on those things? And it's going to be the affected industry. And then, unsurprisingly, the affected industry will send, many of their people will come in and out, right? And I give an example of regulatory capture in the book involving the monks of St. Joseph Abbey in Louisiana. Lovely group of people. And they have a forest, and they used to sell trees before Hurricane Katrina knocked most of them down. And they had to figure out a way to sustain themselves. So they decided, well, we make caskets for our deceased colleagues. And they're pretty nice. So maybe we'll get in the casket business. And so they start advertising. Now, they got the basic model, and then they got the fancy model, but they all come blessed. And they're pretty inexpensive compared to what you're going to get at your local funeral parlor. So what happens? As soon as they start offering these things, the Louisiana Department of Funeral Homes and Casket Makers says that they're in violation of state regulations because they do not have a funeral parlor, they do not have enough visiting rooms, and they don't have enough models and things like that. And the monks reply, well, we don't want to get into the funeral business. You can have these wherever you want, any funeral home. You just take them away, right? And who runs this department? Well, the commissioners, 8 of 9 of them are, of course, funeral home directors, okay? That's regulatory capture. And so the monks go on like a decade-long odyssey trying to change the law and litigation and spending God knows how much, and they eventually win. So that one has a happy ending. But that's the problem of regulatory capture in a nutshell.
Right. And one of the things that I feel like the upshot is the diminution in the respect for the law itself. Yeah. And you make the point around, because it's so voluminous, because it's so confusing, and we've departed from so many of the basic concepts of what the common person would call fair, that you might just say, screw the whole damn system. It doesn't work. It's not for me. the concept that struck me, that drove that home for me, was when you described how the mens rea fundamental tenet of really appreciating intent behind a legal violation as something so fundamental to our system has been summarily dismissed so many times. Yeah. And if that happens, you look at it and say, are we really just at the whim of the people who pick up the rules of that day and want to enforce what they want to enforce?
So mens rea just means your mental state. And traditionally at common law, the prosecutor would have to prove that you did a bad act with a bad mental state, okay? And in many, many of these new regulatory laws, that's not required anymore. We also have a principle, you guys know this, ignorance of the law is no excuse, right? And that makes sense when you have a body of law that basically reflects common norms, right? I shouldn't have to teach you as an adult that you're not to kill or steal or maim another person. But what if the law, you have no idea? What if you can't know? What if it's buried in one of those regulations, right? You have no idea of. I got a story in here about Bobby Unser, you know, the race car driver. That's my mens rea story. It's kind of fun. It involves snowmobiling in Colorado. But you can wind up being a federal felon without any mens rea, without any mental state, and you will be ignorant of the law, and that's no excuse. And those things, I worry when you, and I'm fine with ignorance law is no excuse when, again, it reflects common norms. But when you move beyond that and expand law into so many other areas, does it diminish our respect for law when you can be trapped like that? When every one of you, by many accounts, has probably committed a federal felony? Unwittingly. What does that do for our respect for law? Because I care about law, and I want respect for law, and I think that is essential to a democracy.
And in your legal career, have you seen a diminution in the respect for the law in all your various posts?
I mean, you know, I think you see it in a lot of subtle ways and real concrete ways. I mean, subtle ways. Polls suggest today that maybe a third of millennials don't think it's important to live in a democracy. We are increasingly we think people with whom we disagree are not just wrong, people on the other party, but that they're evil. And I just think our respect and our affection for our institutions is at stake.
And COVID. How did that impact the trends that you're talking about?
Well, I do talk about this in the book a little bit. Because I think COVID was a bit of a microcosm for all of these things. What happened during COVID? Our courts largely fell silent, our legislatures largely fell silent, and executive agencies issued emergency decrees that changed from week to week, place to place. Now, I am a firm believer that in emergencies you need firm and fast executive authority. I also believe in the importance of expertise. But do you lose something when you stop engaging the legislature? Francis Galton, who was a cousin of Charles Darwin, went to a county fair in England and observed that there was a guess the weight of the ox contest. And all the experts listed their guesses, and so did all the average people. And if you actually tallied up all the average people's guesses, it was closer than any of the experts. And we call that today the wisdom of the masses. And I really think that's what our legislative process was meant to embody, was by getting 535 representatives in Congress and however many in your state legislatures, you're going to get all the ideas. They're going to really get tested, right? We're going to get refined. And there's going to be a compromise that reflects the wisdom of the masses. I think that's the idea behind our Constitution. What happens when you take it out and you give it to an expert or one person, a governor or a mayor? Are you more likely to make mistakes? So cases I saw during COVID, In Nevada, is it any surprise that churches were absolutely limited to like 50 people per institution, regardless of their size, regardless of whether they had social isolation rules, masking requirements? It was 50 people, no matter what. Caesar's Palace, basically unaffected. Basically no restrictions. In New York, your marijuana dispensary and your liquor store, good to go. Churches, many of them, again, closed. In California, Hollywood could sing, but you couldn't sing in church. And again, I'm not saying that some strong executive action, I'm just saying, do we lose something when we move our lawmaking out of the legislative branch and put it to well-intended experts or politicians in the executive branch?
And sometimes the experts that talk about regulatory capture, they're not necessarily experts. They happen to have their own self-interest first and foremost.
Well, the whole idea came from Woodrow Wilson, right? I mean, Woodrow Wilson, he believed our traditional three branches of government was antiquated. And he really admired Prussian bureaucracy. It's true. Now, a lot of it had to do with his view that when you had more people vote, when it wasn't just white, male, landed gentry voting, but you allowed women and other minorities to vote, he was very distrustful of that. Now, Prussian bureaucracy didn't look so good 30 years later, but let's leave that aside. He believed in experts. He really believed in rule by experts, and he set up the FTC. That was one of the first alphabet soup agencies. Well, by the time Franklin Roosevelt came along, you know, the idea of the FTC being run by experts, it was mostly run, who winds up getting those jobs? It wasn't PhDs in economics. It was old politicians. And there's a story in the book about FDR trying to remove an old Republican politician with whom he disagreed, and he wasn't able to do so, at any rate. So, yes, I will agree with you. I think there are some real experts. We do need to tap their wisdom, and there is a way to do it. They can advise those who make our laws, and those who make our laws should be our elected representatives.
Now, that's exclamation point on that one. How about the legal profession? Is there any hope that the legal profession, who's closest to this issue, will be part of the answer, or continuing to be served by the growth of the administrative state?
I'll talk about regulatory capture. Sorry, Dean. So, you know, we are allowed to regulate ourselves effectively as lawyers. Our rules are usually set by our state Supreme Courts, okay? Who's on those? Lawyers. And I do worry that we are contributing to the problem, and there's some of this in the book. And let me just give you a few examples. Why do we have 3 years of legal education postgraduate? Now, I am not saying you don't need a good legal education to be a great lawyer. In England, though, you can get a law degree after 3 years undergraduate education. Here we take 7 years of very expensive training, right? And I went back and I looked. Where did the ABA come up with 3 years? Well, it was about 100 years ago, and they said, well, medical school's 4 years, and we're important too. That's how we got 3 years. And here's another one. There's a rule against the unauthorized practice of law except for anybody who's a lawyer, right? But what's the unauthorized practice of law? Nobody knows. Nobody knows. But I do know that every time, you know, like LegalZoom or some innovative service tries to come into a new state, they get whacked for violating the unauthorized practice of law rule. And it's never a client who's upset because, like, and I'm not picking on LegalZoom, but there are a lot of very inexpensive services that can give you basic legal services at a very reasonable price. The consumers are by and large very satisfied with this. It's the lawyers who bring the complaints and try and keep them out. Regulatory capture. And so we do need to do a better job as a profession reflecting on these things. And there are some good models around the country and innovation that's going on in my home state of Colorado. They're licensing lawyers to do like family law. And in Utah and California, there are similar examples. There may be in Texas, I don't know. But there are innovations that are happening. But it's hard because convincing lawyers they're going to lose business is tough.
Okay, so let's talk about solutions for the few minutes we have remaining. De Tocqueville warned that as people get less active, there's a real risk that the government could become more centralized. And today you mentioned that 80% of rulemaking comments get 10 or fewer comments during their comment period, and a third of all rules have 0 comments. Yeah. Is it our fault? And I say our, is it the public's fault that we're asleep at the switch and we kind of get what we deserve?
Yeah. So I'm often asked, Gorsuch, what are you going to do about this? And the answer as a judge is, I can't do much, right? My job is to apply the law you give me, and I will do so faithfully as I can. And my colleagues do, and that's our role. It's getting back to what we talked about earlier, Ken. I think ultimately this is a supply and demand issue, and it's going to come from you. And instead of asking your state house representative, how many laws have you adopted? Maybe ask him how many he's repealed, right? Maybe you look at state licensing laws. Here in Texas, hair braiding. Oh God, there's a story in the book that'll make you cry. Isis Brantley was made homeless because she couldn't hair braid because she didn't have a barber's license. You now license, Texas at one point licensed 500 occupations. It's gotten better. But there's a lot you can do, and I think it's going to happen at the state level, primarily first, where you're going to make a difference. But do I think you can actually make an effective change on the federal level too? Yes, I do. And it has happened, and it can be done on a bipartisan basis. Can I give one example? It involves my dear friend, former colleague, Steve Breyer. Back before he was a justice, he worked for Ted Kennedy in the 1970s. And there was something called the Civil Aeronautics Board. Talk about regulatory capture. You could not start a new airline. An airline couldn't come up with a new route. You couldn't change your fares without the approval of the Civil Aeronautics Board. There were very few airlines in this country, and very few people could afford to fly. Now, it was a very pleasant time when you did. But it was hard. And Steve and Senator Kennedy, on a bipartisan basis with the Ford administration, and then ultimately in the Carter years, decided this was crazy. And they abolished the entire agency, got rid of it. And as a result, airlines have sprung up, fares have come down, we all fly. It's a pain now, but so it can happen on a bipartisan basis. You just have to demand it.
I want to shift gears, just as we finish, to talk about the Supreme Court, if you don't mind.
Sure.
There's 9 of you. There's a lot of mystery around judges in black robes. How do y'all get along and talk and interact, kind of away from what the public might perceive?
Yeah. Well, if you work with 9 people for your whole life, are you likely to want to get along? You betcha, of course you are. And I think of the Supreme Court as a family. Do families have disagreements and different points of view? Yes, of course. Justice Breyer, whom I mentioned, believes in purposivism and interpreting statutes. I believe in following their ordinary public meaning. Just a difference in philosophy and how we read statutes. We will disagree on statutory interpretation routinely, but we had fun doing it, okay? And we know what we're going to disagree on. It's no surprise. But it's remarkable how often, to me, how often we do agree. And I think that's not always as well publicized. So may I give you just a few kind of facts and figures that I think of in my daily life. So we decide about 60 or 70 cases a year in our court. There are about 50 million lawsuits you guys file every year. You are a litigious bunch. Okay? Almost all of them are resolved at the trial court level. Somebody wins, somebody loses, you settle, and you accept it, and you move on with your life. Okay? Very few cases make it up to the Court of Appeals, like my old court on the 10th Circuit here, the 5th Circuit. There you got 3 judges. I sat on the 10th Circuit for a decade with judges appointed by President Obama back to President Lyndon Baines Johnson. Okay? On the cases, the few cases, the tiny percentage that come to appeal, we'd agree 95% of the time. Wow. That's how stable our decision-making is. The Supreme Court only hears cases that are of supreme importance, but most of what we hear is where the lower courts have disagreed. Well, we call them circuit splits. And that's because your rights under federal law can't be different in Texas than they are in California. We have to read the law the same. The Constitution has to mean the same thing everywhere, federal statutes. There are only about 70 of those cases a year in this country, folks. That's it. Okay. And they've disagreed in the lower courts. Now I have 9 people I have to deal with rather than 3. Can you get 9 people to agree on where to go to lunch? We reach unanimity about 40% of the time. I think that's magical. Where lower courts have disagreed, we find agreement. Does that come easy? No. Can you do that with people who don't like and respect each other? No. That's hard work. That's give and take, that's listening as well as speaking, right? Steve Breyer used to like to say, if you listen to someone talk long enough, you're likely to find something you can agree on, maybe start there. Now you say, well, what about our divided cases? That's about 1/3 of our docket year to year, 6-3, 5-4, and maybe half of those are the 6-3 or 5-4 you're thinking of. The rest of them are all manner of 6-3, 5-4. So it's a tiny fraction of cases that people focus on, and I accept that, I understand that. But that isn't a fair view of our law and the work of the court as a whole. Oh, and by the way, those figures, about 40% unanimous, about 1/3 divided, but only about half of those, the ones you're thinking of, those numbers are about the same today as they were in 1943. Back then, Franklin Roosevelt had appointed 8 of the 9 justices on the United States Supreme Court. Today, we've been appointed by 5 different presidents over 30 years. I think we're doing okay.
Okay. A current events question, and if you're uncomfortable answering it, just ignore it. President Biden came out with comments around enumerated reforms of the Supreme Court, and you were quoted as saying, "Be careful." Would you want to talk about what you meant by that?
Well,
because it's very topical today.
Well, all I said, I'm not going to talk about particular proposals. I'm not going to get into it's a political season. I don't want to do any of that.
Good.
What I did say, and what I hope people take away from what I said correctly, is we've been given a very magical thing in our Constitution. It works. It's the most successful democracy in the history of the world. And one element of that is the judiciary and the promise that when the government comes for you, or when you have a disagreement with your neighbor, that you can stand before a judge who owes no allegiance to anybody, and a jury of your peers, and they will decide the question, not somebody who's going to maybe explicitly or implicitly owe some subservience to a politician. And so I would just say, Madison set this thing up very carefully. It's worked for a very long time. I think it's a miracle. Daniel Webster said it's a miracle. He said it took 6,000 years of human history for it to happen, and miracles do not cluster. And don't expect what happened here to happen often or happen easily. That's all I'm trying to say.
Okay. And to that end, your book describes in so many interesting stories and in detail on how the sheer weight of the administrative state is undoing many of those principles that we need to be mindful of. So the book and the stories are really, really powerful. Before we wrap up, I'd like to wrap up with a lightning round. If you don't mind.
All right.
Which I enjoy doing. I don't know so much if the people I interview enjoy it, but okay. If democracy were a stock, would you be long or short?
Long.
Which teacher had the biggest impact on you?
Father Byrne.
President Obama was a Harvard law classmate of yours.
Can I say something about Father Byrne?
Oh, please say something about Father Byrne.
He took this kid from Colorado who wore boots and didn't have very good study habits and was pretty lazy. And he made him a man. And, PhD from Harvard, classics, teaching Latin to spotty sophomores in high school. And, humble, kind, whip smart, selfless. Thank you.
Great. No, thank you. President Obama was one of your Harvard Law classmates. Did you all really think that one day he would be president?
I don't think any of us were thinking about any of that back then. We're trying to get through torts.
What book is on your nightstand now?
Oh, I just finished Blood and Thunder, Hampton Sides, story of Kit Carson and the Navajo. It's a great book.
Okay. If you weren't a lawyer and now a judge, what profession do you think you would have ended up?
Well, I got asked this question at Harvard, and I'm sitting with a bunch of my colleagues. They made us go up for the 400th anniversary or whatever it was, 200th, I don't know, whatever, Harvard. I didn't want to go, but they all, everyone else was going, so I went. And they asked me that question. Everybody else wanted to be an English professor or a history professor. I said I probably would have wound up being a fly fishing guide.
That's what I...
Got reported in the newspaper as I wanted to be a fly fishing guy. I don't think in Boston they know what a fly fishing guide is.
Your Starbucks order, a fancy latte with soy milk or straight up coffee?
Jesus, no. Coffee black from the machine in my office.
Okay. And what keeps you up at night?
Some of these things, cases where the law requires you to do something that you really worry about for the country.
And what are you optimistic about?
The country.
Great. Thank you for coming out. It's a real treat for us. It's a treat. And stay with us. I have a couple of announcements.
What?
Stay right here. I have a couple of announcements.
All right.
Couple quick announcements, but I do want to thank Justice Gorsuch. It is a treat because the Supreme Court is such an enigma, and when you come out, when you write and you speak, and your colleagues do the same, it is so refreshing for the whole country, and it means so much to more, not just for us here, but for everybody who will participate in listening and watching to all that we say. So thank you so much for doing that. I want to thank NexPoint for endowing the series. And a couple quick announcements before the Justice goes to sign books. On 9/11, the museum is going to open at 8 in the morning, and at 8:30 we're going to have a moment of remembrance. And the museum will be free all day on 9/11. It'll be open from 8 in the morning to 8 p.m. September 24th, our Engage series will focus on the Russia-China challenge. We have former U.S. Ambassador to Russia, John Sullivan, former PayPal CEO, Dan Schulman, and Bush Institute fellow Ellen Bork will be joining us for that. On October 9th, Sharon McMahon will be back to talk about her book, The Small and the Mighty. Due to popular demand, that has been moved over to McFarland. There's several thousand people who have signed up for that one. And then on October 28th, Jared Cohen will be here to discuss the purpose behind Beyond the White House, presidents after their presidencies. So thank you all for coming, and Justice Gorsuch will be in our Hall of State room immediately following to sign books. And once again, thank you so much for being here.